Good morning, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions, a national notice to owner service. On our webinar this morning, we have Alex Barthet, a board-certified construction attorney, to assist with any questions that we have at the end of the webinar. And today we have a very special guest, Warren Alter. He is the founder and president of Alter Surety Group. He has over 25 years of experience. And today, he is going to discuss, I've received a claim on my payment or performance bond, now what? Please hold all of your questions until the very end of the webinar. You'll see on the right-hand corner, there's an area for you to ask any questions. And if you would be so kind as to leave out any names, that would be great.
Thank you very much, Ariella. Again, everybody, my name is Warren Alter, and I'm with Alter Surety Group. I'm the founder and president, and have been providing bonds to the South Florida area for over 25 years now, and proud to represent contractors of all sizes and trades, and also fortunate to represent over 35 different insurance companies. So I love what I do, eat, sleep, and breathe, providing bonds to the construction industry.
And my name is Alex Barthet. I'm a board-certified construction lawyer. And today, Warren and I are going to walk you through the topic of what to do when you get a payment or performance bond claim. So we're going to go through these issues. What is a payment and performance bond? What is the first notice that you will likely receive when you get a claim? What steps should you take once a claim is made? And again, we'll answer any questions that you may have at the end. And as Ariella mentioned, just go ahead and type them in and we'll take care of them at the very end. Just make sure not to include any names so that we don't offend the innocent. So Warren, why don't you start by telling us what is a payment bond and what is a performance bond?
All right, thanks, Alex. Although we always hope our projects will be perfect, sometimes things go wrong. That is one of the reasons owners bond their projects, to have somewhere to turn when the contractor gets in trouble. The other reason is to have an independent third party, a surety, verify the contractor is in fact qualified to perform the job. This is called the pre-qualification of the contractor. In its underwriting process, the surety evaluates the capital, capacity, character of the prospective contractor to assure the project owner that the contractor is able to complete the project before the surety commits to provide the bonds. So basically, bonds, I'm going to give you a little bit of a background before I jump into exactly what the payment and performance bonds are. But basically, the bond is comprised of a three-party agreement. You have the principal, which is typically the contractor, or it could be a subcontractor. You have the obligee, who gets the benefit of the bond, or the beneficiary. And then lastly, you have the surety, which is the insurance company. Bonds are a non-traditional insurance product, and they are underwritten for zero losses, which is unlike normal insurance. With normal insurance, you have actuaries and statisticians that basically calculate for every dollar they take in premium, how much they expect to pay out in losses. With bonds, the sureties charge a very nominal fee, could range anywhere from 0.5% to 3%, depending on numerous factors, the surety involved, the financial strength, the relationship, etc. So if there is a loss, a surety looks to be made whole or indemnified. So bonding is a little bit different than your normal insurance. It's more similar to a credit product such as a bank loan. So that's kind of a roundabout nutshell briefing about the bonds. As far as the payment bond is concerned, which we'll talk about now, that's mandated by law as it relates to public and federal projects. And what the payment bond does, it basically protects subs and suppliers who do not have the ability to lien public property. So public property can't be liened. So the only stopgap for subs and suppliers on a project is the prime contractor's payment bond. As it relates to private jobs, it's not mandated by law, and that's up to the discretion of the owner and or lender on that.
How about a performance bond, Warren?
Well, as it relates to a performance bond guarantees all the contract terms, conditions, specifications, the agreed upon contract sum, the specified duration of the project. It encompasses any delay damages, the warranty provision. So basically, the bond is typically on the hook for everything that's within that contract. The bond is basically guaranteeing. And one more thing, the performance and the payment bonds typically go hand in hand. So they're always issued together. and typically 100% performance bond, 100% payment bond.
And when you say 100%, it's the contract sum, correct?
Correct, yes.
And then you mentioned something about indemnity. I guess it's also called the General Agreement of Indemnity. Can you describe what that is?
Yes, the General Indemnity Agreement or General Agreement of Indemnity is an agreement that takes place that's always required in the surety relationship between the principal and the surety. And it's a very one-sided agreement, and it kind of lays out the rules and conditions in the event the surety incurs a loss or anticipates incurring a loss. And in that agreement, as I mentioned earlier, bonds being an indemnity product, if the surety does have a loss, they look to be made whole. And it being a credit product and the surety being an unsecured party, they require that they get the personal guarantees of the stockholders of the company, as well as the spouses of the stockholders as well.
So does the bond protect the contractor that issued the bond or no?
No, the bond is not there for the protection of the principal or the one that's obtaining the bond for the obligee. The bond is for the benefit of the obligee, but it's the contractor that has to go and obtain the bond. They have to qualify with the surety and go through the pretty strenuous underwriting process. The relationship exists between the surety and the principal, and the obligee is the third-party beneficiary to having the bond.
Do you find that folks come to you to get bonds, even if they don't actually issue bonds, just to say they're bonded, that it's a competitive advantage?
Yes, because anybody that has any knowledge of bonds as it relates to being an owner or lender knows that a contractor that is bonded has gone through a strenuous underwriting process where the surety basically has pre-screened and has done their underwriting due diligence. They've evaluated the contractor's background, the jobs that they've completed in the past, the sizes of the jobs, the financial strength of the company, the cash flow of the company. And then basically a bonding company that's willing to provide a bond is basically endorsing that contractor and backing it with their own financial resources in the event that the contractor should default. So a bonded contractor has been through a strenuous process, unlike one that may not have obtained bonds.
So when a claim is made on a bond, what is the first thing that I, as the bonded contractor, am I going to see? So let's take, for example, a payment bond claim. I'm a contractor. I've gone through the effort of getting bonded. I have a payment and performance bond. And now on one of my projects where I have a payment bond, I get a claim. What is typically the first thing that I see, and that as the contractor, and that you see as the agent for the surety? That
would be the notice of non-payment. And notice of non-payments are very common, and we see them with high regularity, if you would. Majority of the time, it's just a timing issue. And what the notice of non-payment is you have a sub or supplier that has not been paid, and by statute are required to provide this notice to preserve their bond or lien rights. Because most general contractors in their subcontracts have a pay when pay clause. And if that time period starts to stretch out and approaches that 90-day period, if one does not file a notice of non-payment within the statutory time, they could lose their lien rights or rights to go against the bond. So it's very, very important that a contractor, a subcontractor, or vendor that hasn't been paid goes about providing this notice of non-payment.
And then what about on a performance bond?
On a performance bond, basically that's typically of a little bit more concern when I would see something like this. And it usually comes in the form of a default notice or a notice to cure, or in a worst case scenario, a termination for cause. This could be for a multitude of reasons. Typically starts off some dialogue with the surety, communication between the bonded principal and the surety, as I mentioned. And under these circumstances, it is of concern to the surety. And at that point, sureties will start to gather up information. They might end up engaging a third-party consultant and or legal counsel as they start to venture into the early stages of such a notice.
Now, what we see when we have clients that we're helping through a claim process, which, by the way, could be on either side. We may represent a party that wants to make a claim on a performance bond or helping a contractor defend a claim against their performance bond is we look through the bond itself and the contract, and we try to figure out what are the rules that apply, because every bond is a little bit different, every contract's a little bit different. So we look to see what notices are required. Have those notices been sent? Are they supposed to be in writing via certified mail? Are there meetings? So would you agree one of the best places to look to see what the process and the notices that a claimant is going to receive is the bond and the contract?
Absolutely. Typically, I'll read a couple sentences from the AIA A312 payment bond form. If there's no default under the construction contract, owner must first provide notice to the contractor and the surety that the owner is considering declaring a contractor in default. So in other words, the surety kind of outlines in their performance bond that they look to be put on notice of a potential declaration of default. And then following that, they would, at that point, default or terminate the contractor and notify the surety of such. And then lastly, the owner would have to agree to continue to provide any remaining contract balances to the surety at that point in time.
The bond form that you read is just one bond form, right? So not
Correct.
Every performance bond is going to follow those steps. So that's why it's really important to look at the bond form, right? So some may have one notice, some may have two, some may have no notice, right? I mean, no
very
precursor. Okay.
Every public owner out there has their own drafted bond form. The AIA is very commonly used in the industry, especially as it relates to private projects, but every public owner, whether it be federal or city, county, state, all have their own drafted bond form. So as you mentioned, it is of critical importance to know exactly what is in that particular bond form.
All right, so now we have an idea of what document we're going to get when someone's making a claim. So the next question is what do we do? What do you tell your clients that they should do in order to try to solve this problem?
The first item, which I can't stress enough, is communication. This is the most critical component of there being any kind of claim against your bond. This is key. It's very, very important that the bonded principal be proactive. If they're knowing that an event is about to take place and the surety is going to be put on notice, it's very prudent for them to contact their agent, let them know what's expected to come down, get the surety engaged in the situation, because it really comes across well when the surety has a heads up about what's about to be coming. So communication is of utmost importance. And then I basically guide them to make sure that they've gathered all their facts, their correspondence, their documentation, any pictures, and everything that they've hopefully organized throughout the project's progress, so they have that readily available for the surety and or their attorney.
Because the surety is going to want to see all that, right? They're going to want to know what's happening on the job, because the surety isn't in tune with what's happened on the job. They issued the bond, they did their underwriting for the company, they learned a little bit about the job when they issued it, but from that point, typically until the claim is made, the surety doesn't know what's going on. They have to catch up now, right?
Exactly. And they're going to do their investigation and evaluation of all the facts. They will give the owner or obligee an opportunity to hear their side. And basically, they look to get every possible information that they need. And if needed, they will also engage third-party consultants and experts to assist them with evaluation.
What I have found works best is letting the surety know in advance of a claim, that you have a concern, the owner's not paying, the owner is complaining the job is late. Let them know in advance that you think something may be coming, letting them know that you're proactive. I've retained an expert, I've retained legal counsel, we have a plan going forward, here's that plan. If a claim is made, then have all your documents ready and readily available. We find that when we have really organized and thorough documentation, the surety and their consultant is typically much more at ease because they see that the job has been managed well. When we have clients that have very sparse documentation that is not well organized, the surety typically gets nervous. They may take a more active role in the process. You see the same thing?
Oh, absolutely. It's critical, and there's a lot of confidence that the surety's claims department have when they know that their client, the bonded principal, is staying ahead of the situation and being proactive as opposed to reactive.
So one of the things we counsel clients on once a claim is made is we, again, remind them of their personal obligations under the general agreement of indemnity, because we find sometimes that they forget that if this claim goes forward and the surety has to do something, that not only are they corporately liable, but they may be personally liable. Do you see the same thing?
Oh, absolutely. Every bonded contractor, has to be cognizant that they have to hold the surety harmless from any losses or loss expenses. Payment bond claims, which could turn into lawsuits, the bonded principal's goal should always be able to get your surety on board and have the surety tender the defense to the bonded principal's attorney so that only one attorney is being paid and not two, where the surety isn't engaging their own attorney in the event there is litigation that ensues under the payment bond, for example.
How important do you see the fact that the bonded principal finishes the job versus either walking off or getting terminated?
Assuming you have the financial means and capability, it's always best to finish the job and fight it out after. There's a lot of very tough contracts out there, and failure to finish the job can be grounds for default and terminations. So that would prompt the surety's involvement. So you always want to try to keep the surety at bay as long as possible, if having to get them involved at all. So performance bonds always are much more complex and riskier than payment bond claims, which are quantifiable. So in the event the contractor has the ability to finish that job, that's always everybody's preferred approach to getting the situation resolved at the best possible scenario to both the contractor and the surety.
One last issue is that we hear every once in a while, from some bonded principals, they say, well, I don't have to worry so much because if I get terminated or if the owner places me in default, or even if I'm a sub and the contractor defaults me and they make a claim on my bond, the surety is going to have to get paid the remaining contract balance, and the surety is probably just going to hire me anyways to finish the job, so my risk is small. What we see when that happens, what we tell clients when they tell us something like that is, number one, it's not a sure thing that they're going to finish the job. It's not a sure thing that they're going to hire you. We've had claims where our client was defaulted and the surety just decided to write a check, and then they turn around and look to the principal to reimburse them. Do you ever hear that pushback from some clients?
You do hear that, but everybody needs to keep in mind the surety is going to do what's in their best interest, not so much in the bonded principal's best interest. So in the event the surety finds themselves in a claim, their approach is going to be to get out of the situation at the least costliest approach. And the terms of the indemnity agreement allow them to proceed on that basis. So the bonded principal is more at risk than maybe they would think under the scenario that you just mentioned.
Perfect. So if anyone has any questions, go ahead and submit them. Ariella, do you see any questions in the chat box?
At the moment, I don't. I think you both did such an extraordinary job.
Let me just emphasize a couple points that I hope that the listeners will walk away from as it relates to if they find themselves in the situation. And I've always said it as it relates to construction and bonding and construction contracts, fighting with the subs, fighting with the owners. It's not a matter of if, it's a matter of when you'll find yourself in some type of situation. Severity could be minimal, severity could be significant, but the two things that I would like for the listeners to keep in mind is communication and being proactive in a situation is of utmost importance. Secondly, is having an excellent construction attorney who not only knows the laws, but will also provide strategy in moving through the maze, because every situation is so unique to itself. And having an excellent construction attorney involved with your situation is a huge benefit to you.
Well, I want to thank both of you very much for the fabulous educational webinar. And I think that if you are looking for an expert in the legal field, then Alex Barthet is available and we will provide his contact details. And if you're looking to bond a project, then absolutely you should speak with Warren. And I know that Alex has one more for us for our next seminars and webinars.
Right, so our next live seminar titled Understanding Liens, Bonds, and Contracts to Get Paid Faster is on September 19th from 8 to 11 in Naples. And our next webinar is July 20th from 9 to 9:20. And we're going to talk about how much credit should you extend to a customer. You can sign up for all of these seminars and webinars. The webinars are free. There's a small fee for the live seminar, sunraynotice.com/education.
Great. Well, if anyone has any questions and they were nervous to ask over the messenger, please feel free to send us an email and we will get back to you before the end of the business day. And once again, Warren and Alex, you did an absolutely brilliant job, and thank you very much.
Thank you very much. Have a great day, everybody.